Hello, welcome to the Law Awareness Weeks at CDC 2020. The Law and Me Stronger Together. This is organized by the Law Society Pro Bono Services and the 5 community development councils with the strong support of the People's Association, National University of Singapore, Singapore Management University, Singapore University of Social Sciences, and the Singapore Corporate Counsel Association. I'm Serene, and I'm your host for this webinar. Today's webinar is Landlord and Tenancy Matters. Before we start, some housekeeping matters. Relevant materials for today's talk can be downloaded from the handouts section, which you can see on your screen. If you're using a mobile phone or tablet, the icons should appear on your top right-hand corner. On your computer, you should see the icons on your right. Please download these materials before the end of the talk. Feel free to ask any questions during the webinar. You can type them into the questions section and click send. Your questions will only be seen by the organizer. We will do our best to address your questions during or at the end of the talk. Please note that the discussion and any materials provided in this webinar is not intended to substitute or constitute professional legal advice. If you require legal advice, please consult a lawyer. I would like to introduce our panelists for this webinar, Mr. Richard Xiao and Ms. Renita Crasta. Richard is the founder and current managing director of R.S. Solomon LLC, a full-service law practice in Singapore. Richard is a general litigator focusing on commercial, criminal, and family matters. Effectively bilingual in English and Chinese, Richard is one of the People's Republic of China Embassy's 5 panel lawyers in Singapore. Renita is a group legal counsel of one of Singapore's largest real estate companies, where she advises on a range of matters from litigation and corporate, real estate and construction issues, to various IP and IT matters. She's the co-chairperson of the Younger Lawyers chapter of the Singapore Corporate Counsel Association. Richard and Renita, thank you for joining us today.
Thank you.
COVID-19 has impacted businesses and their ability to earn money. This creates a problem for tenants to pay rent to their landlords. Their landlords, in turn, face difficulties in paying their mortgage and workers who operate and maintain the property. In response, the Singapore government has passed the Covid-19 Temporary Measures Act to bring temporary relief to businesses. Richard, could you tell us how the Covid-19 Act helps tenants?
Sure. I think there are 2 parts that we can talk about the relief that was being granted to tenants. One, the first part, they call it, or the government call it, as the property tax rebate that the landlord or the proprietors received from the government through the rebate of the property tax payable. And then these are supposed to be passed on to the tenants and including the subtenants. So that's one part. The other part is what the government call it as the cash grant, that for tenants that meets the criteria, and I'll name it in a while, these qualifying tenants then will receive the equivalent of support, and I'll elaborate a bit later after this, from the landlord themselves. So coming back to the first part about qualifying tenant, so there are 3 criteria generally. First, if the tenant can show that their sales or the turnover for April and May this year, compared to the same period last year, decreased by at least 35%, and that their turnover in 2018 was less than 100 million, and that the tenancy agreement that they entered with the landlord was before 25th March this year, and then still effective going into 1st April this year. So if a tenant actually meets these 3 criteria, they qualify for the cash grant. So what's the component of the cash grant? So again, the bill, or rather I should say the temporary COVID-19 Temporary Measure Act, they define 2 classes of property generally. One, it's the commercial, we have the shopping malls and all that. and then we have the offices and industrial properties like the factories and the office that we operate in. For the commercial properties, the total relief under the relief framework is 4 months. 2 from the government through the property rebate, 2 from the landlord through the cash grant. So it's 4 months. Whereas for the industrial and office properties, it's 2 months. So the government bear half, which is 1 month, and then the landlord the other half. So this is the general relief provided by the government through the Act to the tenant. So that's one help that the tenants are getting. The other help comes in the form of moratorium, whereby during the prescribed period, and it's originally was from April to October 19th last month, but then it has been extended to 19th November this year. So during this period, and we call it the moratorium, the landlord cannot commence any legal proceedings against the tenant to recover default rental payments, or even regained possession of the property or evicted the tenant. So this allowed the tenant during this moratorium period to find their footing, to regain their pace, and hopefully recover with a peace of mind. So these are the 2 main tenant of relief provided through the COVID-19 measures. Serene.
Thanks, Richard.
Yes.
Renita, could you, on the flip side, could you tell us how the COVID-19 Act helps landlords?
Thanks, Serene, and glad to be here. Indeed, I think many often mistake that the COVID Act is just for the benefit of tenants, but really it also helps to bring greater clarity to landlords as well, and overall in the relationship between the landlord and tenant to bring a fairer balance, but also fairer understanding. So one of the ways is in the property tax rebate, which is actually in terms of the rebates that we've just talked about, that has to be passed down from landlords to tenants. And through that, we know that the legislation was made much clearer over time to make it very clear that it should be passed not just to the tenants, but to the ultimate tenants as well. I think definitely a lot of the larger landlords started to do this once they could ascertain the amounts. And I think also by now, most of the smaller landlords should have done so. So in addition to that, there are also, as we said, the cash grants and the additional assistance that can be given to certain qualifying businesses. And again, where that is given and it assists the tenants, landlords do have to comply with it. So it's very clear what obligations the landlords have to comply with. And if they don't, with the clear mechanism to help tenants, landlords also can have recourse to that. For any reason, for example, if they object to those computations, they can also go to the same adjudicator mechanism to convey, the hardships, the financial hardship that they may be in, or certain reasons why they think a particular tenant may or may not be entitled to a full measure of a certain relief. At the same time, beyond all this, the Act overall brings a lot of clarity and certainty to the entire landscape. So in this very difficult time, there is a lot of discussion, as to where the responsibilities should lie. Every party does face a lot of hardship. So as much as tenants, of course, have been facing a lot of hardship, and they need the assistance brought about by this Act. At the same time, the Act also does make clear that certain other obligations beyond payment has to still be fulfilled by the tenants. So on one hand, while the tenant may be entitled to maybe deferred payment, or they cannot be evicted from certain premises by the landlord just because of non-payment, at the same time they know that this is just it may just be a deferred obligation. So at the end of the day, for example, if there's certain damage to premises, or if there is certain obligations they have to comply with in their contracts beyond payment, they still do need to comply with these obligations, and they still do need to account for such damage, etc. As part of their usual obligations under the contract. So I think that overall it has given a lot of clarity and certainty between both parties, and you know, hopefully it has also allowed a fairer mechanism during these difficult times for both parties to get an understanding of their obligations, and then to have a recourse, you know, if they need to sort out any of that understanding as well.
Thanks, Renita. We just
Yeah.
received a question from the audience. You mentioned about rental relief, you know, and about property tax rebates. Could we check, you know, is that cap to these reliefs? Is it based on contractually what's the rental amount stated in the lease agreement, or is it basically how much the government has passed on in terms of property tax rebate?
Yeah,
Yes.
I can take it first, and Richard, please
Sure,
add on.
sure.
Ladies
So well, I think in terms of rental relief, I think you know, for property tax, for example, the rebates, it really depends whether you are industrial tenant or a commercial tenant, right? So either the 2 months or the 4 months, and this is computed based on the annual value as well, in terms of the amount that is passed down to the landlords and eventually meant to be passed on to the tenants. And likewise, there are certain qualifying conditions that you have to meet to get the additional cash grant in terms of the size of your business and showing that you have faced certain losses in your profits, you know, from the year before during the period that you may be claiming for, so the April to May period. So in that sense, yes, it is for specific months, and there is a computation figure to it. In terms of whether you're eligible and how much you can get. Richard, did I cover that part? Yeah.
Yes. Also thinking whether I'll be running out of things to say, but just to pick up a point from what you just said about the benefits accorded to the landlord. Before I take Serene's question on the whether how to deal with the differences in terms of the rebate as well as the actual benefit passed on to the tenant. The difference between Renita and I is that Renita act for one of the biggest landlord in Singapore. I'm a small lawyer. I act for small landlords, so I'll speak for the small landlords. Yeah. So the COVID-19 measure actually benefits the small landlords in one way as well. There are also landlords that are in difficulties, very, very severe difficulties, especially those elderly landlords that rely on 1 or even 2 properties as their livelihood. So if these landlords can come forward and show through the notification of relief measure, same as what the tenant will go through the MinLaw portal, Ministry of Law portal, they can also, if let's say they are a landlord for the commercial property, instead of coming up to 2 months cash grant, their life obligation can be reduced to half. So for commercial properties, instead of 2, they give 1, and for industrial and office properties, the landlord, if they can prove that they are financially affected by the COVID, I mean most of us are, then he or she can reduce their commitment by half. So that's the aspect of the benefit from the COVID-19 that is flowing to the landlords, for the smaller landlords. So that's one part that I just want to pick up from Renita's coverage earlier. Coming back to Serene's question about the tax rebate, I think it's important for the tenant to know that the IRAS, the Income Tax Office, has already sent out the letters by this time. Most, if not all, the landlords or proprietors would have received notification from the tax office. In there, it very clearly states the amount that the landlord will receive. And in the letter, it states very clearly that the landlord has an obligation within 4 working days upon receiving the notice to pass this notice to the tenant. And then it says whether the tenant is eligible for 4 months or 2 months, depending on the property type, for the rental relief. So it becomes very clear, like what Renita said earlier, over the months, the law became very clear and it added a lot of clarity to parties. So for the tenants, upon receiving the notification, if they have not received such a notice, they should ask the landlord. It is the landlord's obligation to do so, legal obligation to do so within 4 days. And it becomes very clear how much they are entitled to. So that's one part. The second part is the letter also states, or I would say the law actually says that if the property tax relief, the property tax rebate received by the landlord is actually lower than the rent that is collectible, By right, it should not be, because what you declare as a rental, it should be stamped. And of course, there's a beeline now that a lot of people didn't stamp the contract, but that's a separate matter altogether. But the fact of the matter is that if there's a shortfall, the landlord have to make up the shortfall. So, for example, if let's say the relief or rebate through the property rebate, the landlord received $1,500 when in fact the monthly rental that he collects is $2,000. The $500 shortfall, the landlord has to put up with it. But of course, the excess, the landlord gets to keep it. So I think these two aspects that the tenants should really pay attention.
Thanks, Richard. So I think that's a very important reminder that actually IRAS would have already sent out the property tax rebate, and the landlords are legally obliged to pass it down. So if you have not heard anything from your landlord, please do reach out to your landlord and remind them about this. Let's go through the different case scenarios that are commonly faced by landlords and tenants. Our first scenario deals with a shop. Shop A sells goods and rents a unit at a warehouse to store its goods, rents the ground floor of a shophouse to sell its goods, a family stays on the second floor of the shophouse as their home, pays a fee to a department store to display its goods on a shelf for sale, rents a pushcart at a shopping mall to sell its goods. Due to COVID-19, Shop A suffers a drastic drop in revenue and is unable to pay rent. Renita, for the warehouse, does Shop A have to pay rent?
Yeah, thanks, Serene. And I think that's a interesting, commonly faced scenario by many tenants actually. So either you're in an industrial space or you're more commercial office space. So for industrial spaces, warehouses are usually set out in these spaces, and as such, under the Act, they are entitled to 1 month of rental relief. And where the tenant also fulfills the criteria for additional rental relief, they can get an additional month of rental relief. So, in that sense, the tenant it is provided with certain immediate relief at the initial portion of the COVID period, and certain additional help if they are facing greater losses just during an interim period, as they might, meanwhile get their business plans, back in order, or at least to a state that they can address the current COVID conditions. Unfortunately, the Act doesn't give the mandate to vary other contractual terms, and a tenant would have to discuss this with the landlord, on a case-by-case basis if they need additional relief beyond just this payment relief or some other terms that they might have to comply with. So that would also be another option. And also tenants, even at the warehouse space, should note that, of course, during this initial period, or at least for a 6-month period, or from April to October, there has been sufficient protection as well to ensure that these tenants cannot be kicked out of their premises or their business disrupted. So they are given that protection as well, despite any non-payment, to be able to at least continue their business for a period of time during these difficult times for them. Yeah.
Thanks, Renita. I think on that topic about, I think as Richard alluded to, the moratorium where, tenant can apply for relief such that they're not required to pay rent. We just had a question from the audience that the landlord is charging interest for the late payment during the relief period, even after, serving the notification for relief. So is the landlord able to charge late payment interest?
Yeah, so sorry, Richard.
No, Renita, please go ahead, please.
Okay. Yeah, so certain interest payments, yes, would still be chargeable under the Act. It has not, as far as I understand, it hasn't actually taken away the power for that. However, there are provisions that may go to say, what is an acceptable form of interest rate, and this should not amount to a penalty, etc. So I think in terms of how that interest is charged, that can be looked into. Also, I mean, despite acting, working more with some of the bigger landlords, we do quite a lot of community work as well with many of the smaller tenants, and they are our customers at the end of the day. So, there actually is a lot of concern. There is a lot of discussion that still goes on between tenants, and they do reach out either to their landlords or their relationship managers to try to, on a case-by-case basis, convey the situation they're in and see what assistance can be given. So we would encourage that commercial discussion to still take place to the extent possible, with understanding on all sides.
Yeah.
Thanks, Renita. Richard, do you have anything to add?
Oh, if I may, yes. We have during this period we have handled a few cases whereby, for obvious reasons, a tenant wasn't able to pay, and of course, there's another group of tenants. They also were also sort of wait and see sort of attitude because of the unclear situation in the beginning of the COVID period. So they hold back payment of the rent. So the landlord then charge interest for these late payments. So if they go according to their contract signed, typically a late payment will attract late payment interest of 12 to 15%, depending on how is it terms in the tenancy agreement. So that's hefty, right? But the law for the temporary measure act very clearly states that there's a cap of 3%. The landlord can charge for late payment penalty, but it's capped at 3%. But there's another dimension to it. So let's say, for example, the law also allow deferred payment, which Serene, you mentioned earlier in the beginning of the seminar, where tenants are given the opportunity to defer payment. Such deferred payment, which is mandated by law, though they are delayed, the landlord can still charge late payment penalties, but it's kept at 3%. But if, let's say, the late payment went beyond, let's say, into 2021, January, February, because of the lease, the tenant has given by law maximum of 9 months to repay all the arrears. What is unclear, and of course, from the plain reading of the law, is that the landlord can then revert to the original penalty that's stated in the lease agreement beyond the moratorium period. So if let's say come next year, you're still, a tenant is behind the arrears, at the same time, the new rent is kicking in. So if let's say they are late with the current rent, then the penalty of 12-15% as stated in the lease will kick in. So that's something that I think the tenant needs to be very mindful. Yes.
Thanks, Richard. I think that that's a very good reminder that even though you have this brief relief not to pay rent, but late interest payment is still being accumulated.
Yes.
So, Richard, you had touched on how the COVID-19 Act applies to commercial properties. For the shop house, in our scenario, the first floor is used as a shop and the second floor is used as a home. So is shop A able to rely on the COVID-19 Act for a shop house?
Yes and no, right? Because the COVID-19 measures was very specifically targeted at commercial interests, commercial businesses, right? Sorry, commercial entities and all that. So for the ground floor where a tenant take up a shop space for display, that is part of the commercial activities that certainly would attract rental relief under the framework. But for the unit that the family actually stays in, and assuming that they have the relevant clearance from the authority, that space is actually for a residential purpose, assuming that that's given, then the residential properties do not come under the ambit of the COVID-19 Temporary Measure Act. The Act doesn't provide relief for residential purposes and properties. So to answer your question, Serene, is yes and no. For the commercial aspects of the property, yes, the tenant will receive the rental relief that Renita and I have covered in the early part of this seminar. But for us, for the residential portion of the property, no, the answer is not. They're not entitled to receive that relief. Yeah, thank you.
Thanks, Richard. So we now look at the department store, which is an interesting situation. Here, instead of Shop A renting a shop unit, it pays the department store a fee to display its good at a shelf for sale. In this instance, Renita, would Shop A be able to rely on the COVID-19 Act?
Yeah, so this one is an interesting situation. I think the issue is that really we also have sub retailers. I mean, you have retailers in the malls, and within them, especially in a department store, you may have sub retailers. Sometimes it does depend what is in that contract between the main retailer and their onward retailers. But generally, because this is considered a service contract, and especially if it doesn't amount to an actual license of space, so it's not a dedicated space that is being used by a specific retailer, maybe it's just the use of certain shelves, then it would not actually amount to being considered like a property space, and therefore not entitled to these property reliefs under the Act. So one way to also determine that, for example, is also to see whether you're paying any stamp duty on your contract. And if you are paying a stamp duty, on your contract, that might actually point to the fact that, oh, it's a dedicated space, it's being construed, that you might be able to obtain some relief for this space as well. But otherwise, yeah, it might be a bit difficult. It may be just treated like any other service contract in that sense. Yeah.
Thanks, Renita. I suppose for the the shops who, as you said, it's more of a service agreement rather than a lease or a license. Do you have any tips on how Shop A could approach the department store, to discuss the situation?
Yeah, so I think so this would really be a situation, I mean, like some of the other situations, really quite commercial at the end of the day. I mean, landlords and I think the bigger players, they do take into account, I think at the end of the day, everyone is actually in a symbiotic relationship. Of course, we may say certain parties have more holding power, etc. But I think for every level of the so-called chain or of supply, they have their own hardships. They have been hit in different ways, different considerations. So definitely for the smaller tenants, we would encourage that they should speak with the department store. It is in the interest also of the department store. We would remind the bigger players that it is in their interest to have longevity of many of these smaller tenants, to add to the marketing mix, to add to the retail profile. And I think some of the ways that could be considered, for example, is if the tenant says, maybe I'm willing to sign with you for a longer period, or perhaps to work out some form of a deferred installment period payment plan, right? Which is also allowed under the Act, but in this case, this particular department shelf occupier may not be entitled to the relief of the Act, but on their own they can go to the landlord and they can offer and say, maybe I will stay longer with you if you just give me a bit more time to pay. So I think it's very commercial at the end of the day. And if you can show that it's a win-win situation, I do think many of the department stores or landlords would be open to hearing that argument out. Yeah.
Thanks, Renita. I think that was quite useful tips in the sense that, yes, even though the COVID-19 Act may not apply in your situation, that really doesn't stop you from trying to, be proactive, try and generate options and speak to your the landlord or your counterparty, for that matter, to try and generate some win-win situations. Richard, for the
Yes.
push cart, do you think the COVID-19 Act would apply?
Right, this is a very interesting scenario. And it goes back to what Renita just covered, whereby the COVID-19 Temporary Measure Act covers the particular property that's designated licensed for use and for commercial activities. So then we have to go back to the question, this push cart, does it form part of the landscape of the property concerned? Or is this a temporary shelf, if you like? So it could be a makeshift shelf, if you like. If you look at or characterize it as a shelf whereby there's consignment goods being laid on. So coming back to the basics, if the push cart forms a permanent lease space, and the property, whereby the tenant who took up the space enter leasing agreements with the building management or proprietor, and then stamp duty is paid on that lease, that clearly point to the fact that it is a lease space, and therefore it comes under the protection of the COVID Measure Temporary Act. However, on the other hand, if it's just a shelf but it's in the form of a push cart, then what Renita has covered earlier clearly says that this is not covered under the Temporary Measure Act, and just too bad. In order to sort of work out a win-win situation, and of course, the reader has pointed out the importance of having this long-term, lasting, fruitful relationship between the landlord and the suppliers or the customers or the tenant. Then parties should really work out some sort of ways to help reduce the financial losses for both parties. So one thing I couldn't help to make one cheeky remark about the shelves being empty. It's not because the landlords and the tenants are fighting each other and they don't allow them to put their goods. It's just that very often at one stage when we went to the mall, all shelves are empty because all the consumers just take everything, the toilet rolls and everything. So that's true, and I was one of them actually. I took one of the toilet rolls and all that. But we really needed it, So but people are just looking at us. But my point is, the shelves are empty because the consumers or the shoppers were just all snatching all the what they can grab. Yeah.
Thanks, Richard. We just received a question from the audience. Richard, do you need to have a written lease agreement in order to receive rental relief?
Wow, this is very tricky.
Perhaps in this case, the tenant doesn't have a written lease agreement. Maybe it's verbal.
Well, it's Serene and Rita. We all lawyers, we know that, right? This is contract 101, right? I mean, a verbal contract is just as good as any contract, but the problem is evidentially whether we can prove that it was a contract. So assuming that the legal question, of course, is whether we can prove that there existence of a contract, but the legal principle is a separate matter. Whether it's verbal or written, that it is a contract. If all the elements of the contracts are in place, it is a contract. So what if it's not written? But the problem lies then, what are the terms that was actually communicated? It could be that the landlord say this, the tenant say that, and then each party said its own version. And obviously, each will only say things that is in their advantage. And then when there's no other independent witnesses to verify the terms of the contract, so then whether there was a contract, a meeting of mind, as far as the terms of the lease is concerned, become a question. But that goes into how much perhaps and sort of relief they can get. But obviously, if there's no written agreement, I've been using this place. Let's say I'm a tenant. I have been renting this place as an office for the past 1 month. Past 1 year. Nobody can then say that I didn't lease the space. And nobody can then say that I don't have a leasing agreement with the landlord. I mean, after all, I've been paying rental monthly. So the short answer to that question is, without a written agreement does not negate the fact that there is an agreement in place, and therefore the benefits or the protection accorded under the Temporary Measure Act will be extended to such a situation.
Thanks, Richard. I think you brought up a useful point that it's going to be an uphill hurdle. If you're trying to prove the existence of a lease without a lease agreement. And I also guess it does beg the question of whether the particular audience member did pay stamp duty, because I think, as you all had raised up earlier, right? Normally stamp duty is paid on the lease, and without a written lease, question mark on that aspect. Renita, do you have anything to add?
No, I mean, I think Richard summed it up quite well. Exactly, I think there are a lot of evidentiary issues that come up. Especially if any contract out there is verbal, it comes down to evidence and having to prove it. In particular, for property contracts, we also usually have this acronym PPP, which is the purchase price, the property description, the purchase price, and your period, the length or term of the contract. So these are also quite important elements that need to be determined. That it has to be quite clear, even if at least by conduct you have been paying the same amount, you've been occupying this space for the same amount of price that you've been paying every month, and then to calculate the term. And like you rightly pointed out, Serene, about the stamp duty as well. So I think bearing all that in mind, I think the tenant would then have to go with this evidence and then try to speak to the person that they are leasing or taking up this space from. Yeah.
Thanks, Renita. Let's move to the second scenario. The second scenario touches on a restaurant. The landlord refuses to provide additional rental relief to Restaurant A because although Restaurant A's monthly average revenue had dropped from April to May 2020, its business has recovered from June 2020 onwards. Restaurant B, because Restaurant B's business is bad at the landlord's location, but is doing very well at its other locations in Singapore. Restaurant C, because Restaurant C only commenced business in January 2020 and does not have accounts for April to May 2019. What should the restaurants do? Richard, what are your thoughts about Restaurant A?
Okay. As we discussed earlier, the both leader has stated one important point about having this additional cash grant eligibility, right? The tenant will have to show that there is a drop in their business in April and May this year compared to the same period last year by at least 35%. So the fact that the Restaurant A can show that there's a drop in business as such, they meet the criteria, and that they have a tenancy agreement that was entered before 25th of March, going into 1st of April, still valid, and that the turnover was less than 100 million in 2018, the landlord is obliged to provide that relief. So what that the business pick up in June. In fact, the landlord, if I'm the landlord, I should be very happy that the business pick up, because I'll be very concerned that the tenant can pay me, you know. So it's a good sign. So the landlord should be very happy that the tenant is doing well, and that therefore the relief can be granted. But on the ground, it actually happens. The landlord refused to, first of all, the tenant refused to pay, and then the landlord refused to accord the relief under the Temporary Measure Act rental relief framework to the tenant. So this is where, again, if possible, parties should come together and say, okay, if I don't pay you, say April or May, or the tenant has already paid April and May, then they can be offset for the subsequent months rental, and then parties have to work out together. But it's easier said than done. Very often on the ground, and the kind of issues that we are being consulted on a daily basis is that we have both sides, landlords not passing the relief to the tenant, and the tenant's not paying rent. So that's is really real. But based on this academic question, the answer is no, the landlord has to pay.
All right. So I guess putting ourselves in Restaurant A's shoes. So the landlord refuses to pay. So how do you go about making the landlord pay? I mean, of course, besides reaching out and trying to persuade the landlord to do so, does the Restaurant A have to take legal action, or do they file forms, or how can they compel the landlord to give that additional rental relief?
Right, Serene, I think you mentioned a very good point. Where I alluded to the fact that sometimes it's just ignorant. In other words, the landlord just wasn't sure or got confused or misunderstood the whole framework altogether. It's not that they don't want to play ball, it's just that they thought that they are legally entitled not to pass on. And that happens in the very early part of the year, say in mid-April onwards, and early May, very confusing time that time. During that period, and yes, the landlord just wait and see. Everybody does that. But if it becomes clear that there's an obligation, so first it helps if, let's say, the tenant, for us, if let's say tenants approach us, we actually draft a very friendly letter. Though we want to fight for our tenants' interest, but we draft it in such a way that it's very friendly, educating the landlord, pointing them to the relevant sections of the law that they have such an obligation. Very often this work. Once the landlord understand, and Singapore very kiasu and kiasi one, so they say, oh, there's such a law. Yes, we will play ball. So that solve one part of the problem. The other way of doing it is that, again, we have often also in the letter we say, okay, never mind, since you don't pass it on to our client, that's fine. since you must accept that these are the framework, these are the law, what about for the subsequent months rental? Could we then use that to offset? So that again, that also works very well, because after all, the landlord also doesn't want to fork up money. So we also advise our client, the tenant, perhaps instead of just lump sum, maybe space out the offset, say spread out, 2 to 4 months, so that the landlord still get half rent, rather than a full offset. So at least it provides cash flow to the landlord. Again, it's a sweetener to the landlord. Very often, this also works. Now, the problem lies when, after all this sweet talk and all that, and the landlord still don't budge, and that there are many as such, then of course the tenant have to file a notification of relief through the main law portal, and then compel the landlord to come to the table. Or I'm talking about literally speaking, because now is the COVID period. All the assessors they conduct through like what we are doing now, the virtual, whereby the assessors will be appointed. They look at the case, they look at the party submissions, and then make a deliberation, and it's final. And these assessors, they can then detect the landlord. They must, and it's mandatory by law. And if they do so, it's a breach of the act, and that's criminal actually. Yeah, sorry, Serene.
Yeah. Thanks, Richard. I think that was a good reminder in that, when trying to negotiate with the landlord in terms of the additional rental relief, rather than telling the landlord, please pay me or refund me on the amount, maybe it's easier, as you said, to just offset it, right? So that at least the landlord has some sort of cash flow, because I think, as we've all raised earlier, especially when you're dealing with smaller landlords, they may be facing quite cash flow issues as well, because they have to pay their mortgage, they have to pay the utilities, and etc. So one, I guess an extension of this is one question I had from the audience is, after serving the notification for relief, fortunately the audience members, landlord, basically threatened to evict the tenant. Is the landlord able to do that?
You want me to take a question or read the?
So sorry. So maybe I'll ask Richard first. So what happens in a situation where the tenant serves that Form 1, and then basically the landlord says, I want to evict you now.
Oh, no,
is
no,
the landlord able to do that?
Well. No, they can't do that. Not in Singapore, at least. All right. No, because well, we have both Renita and I have covered this quite extensively in the beginning, whereby there's a moratorium period, and then it's expanded to November 19. So during this period, no, the landlord, no matter how fuming mad they are with the tenant, they can't evict the tenant. Yeah.
All right. Thanks, Richard. All right, let's look at Restaurant B. Restaurant B is an interesting situation. It deals with a business that has different outlets, and each outlet performs differently. Renita, what are your thoughts about Restaurant B?
Yeah, so I think for Restaurant B, and in this query, we're really discussing about additional rental relief. So the COVID Act has provided that, additional rental relief can be given even to SMEs within a group business. And in this case, we are saying that this particular location, they're not doing so well, but at the other locations, they are doing well. So generally, to qualify for the additional 2 months waiver of rental, if you're a commercial property, or 1 month rental or waiver if you're industrial property, you could qualify for that. And beyond, you must have shown that you experienced a substantial drop in your average monthly revenue during this COVID period, which is construed as the average monthly revenue in April to May period. And it is determined at the outlet level, your outlet level revenue must have dropped by at least 35% or more during this April to May period. So this particular outlet may not be able to claim for it at the outlet level, but the other outlets would be able to claim from their landlords because they are able to show that drop in revenue, and they fall within these type of SMEs that have less than $100 million of turnover in the previous year. So as long as they qualify for these two things, they are part of that type of SME in terms of size, less than 100 million. And then secondly, that at the outlet level, they can show that drop in 35% of earnings from the previous year, they should be able to qualify for this additional rental relief.
Thanks, Renita. So from just a point of clarification, so I gather from what you said is that they will look at the outlet in question. So if your outlet is doing well, then they cannot claim for rental relief. But if the outlet is doing badly, they can claim for rental relief even though other outlets throughout Singapore is doing well. Is my understanding correct, Renita?
That's right. So I think based on the current wording, they have phrased it as at the outlet level. So they would look at that particular outlet to determine the accounts. Another point I'll just bring up is also that there are quite a number of tenants we have seen on the ground that they have asked us as well in external work as well. When in external discussions, when we speak with them, they ask why must they show some of their accounts to the landlord. They are, in fact, some of them are quite upset that they have to reveal some of these accounts to the landlord. But I think on both sides, for example, if the tenant wants to qualify for this relief, unfortunately, they do have to prove with a certain amount of evidence that they have suffered this drop in earnings. And likewise for the landlord, if they are trying to claim for financial hardship, they too may be required to show a certain amount of evidence that this is a real financial hardship that they are suffering. So the process is quite fair in that way. And this is important for both sides to understand. Yeah.
Thanks, Renita. I think that's such a useful and good reminder that you need to help yourself as well. If the other side asks you for supporting documents, do help them, because they also need to perform an objective assessment of whether you fulfill that criteria. Renita, there's a question from the audience. We have discussed about tenants filing Form 1 if they do not want the landlord to take action against them. On the flip side, if the landlord faces hardship and the tenant does not want to pay rent, what should the landlord do if the tenant does not file Form 1?
Sorry, just to clarify, so you're saying the tenant is not filing Form 1, but they are still
Correct.
not paying rent. Is that correct?
Yes. I think maybe I'm looking into the audience question. I think what the audience is getting at is, look, landlord faces financial hardship. Tenant doesn't, I think in this case, doesn't fulfill the Covid-19 Act, but tenant refuses to pay rent. So what should the landlord do?
Yeah, so in the event of any dispute, I mean, there are actually two ways about it. I mean, commercially, landlords do have a little bit more power at times, especially because they do hold a security deposit. So that's a commercial angle of it, in terms of how sometimes the landlord enforces some of its remedies. But of course, most landlords would also want to keep this deposit for, actual instances that, there are other instances that they could suffer under the contract, depending on the remaining duration of the contract and depending on other circumstances like damage or certain things that could happen. So security deposit is there for all those reasons. But more particularly, the better way to probably deal with it is under the COVID Act. There's a very clear mechanism set out for the landlords to also make use of that mechanism to go to an assessor and say that, prove that they have financial hardship and that the tenant is not paying them, bring the tenant to the table, or at least clearly let the tenant know that, the landlord is rightfully asking for this rent. Yeah, so of course, I'm quite sure the landlord would first, of course, try to speak with the tenant, send letters, gain understanding. But if that's not possible, definitely the mechanism is there for landlords as well.
Thanks, Renita. So let's look at Restaurant C, and I think Restaurant C is, it's a new restaurant. So commenced business in January 2020, and so they do not have the accounts for April to May 2019. So it's a bit more difficult for them to prove that there's a drop in business. So Richard, for Restaurant C, what are your thoughts?
Well, they still have to, like what Renita has said, that in order to benefit from the protection accorded under the Act, some evidence must be provided. So the law doesn't dictate what form, as long as the applicant It could be the landlord or it could be the tenant. In this instance, it would be the tenant, the restaurancee, to be able to provide some sort of figures. It could be the daily sales. The cashier machine would show anyway, right? What sort of business drop they have suffered over the period. And the other way of doing it is that they actually make a declaration. The law allows them, and then the notification of relief framework allows declaration as a form of evidence. In other words, the tenant or the landlord come forward, make a declaration, statutory declaration, signed before a commission of oath, and we have done quite a fair bit of those, and then that can be tendered to the assessor, and that is accepted as an evidence. So I'm not suggesting, but there are, of course, cases whereby people still lie under the oath for whatever reasons. But by and large, we are saying that if you dare come forward and make a statutory declaration that you have suffered certain losses, and you laid out the basis for your declaration, that is accepted as evidence, and that the assessor will take into consideration. So despite that, they are not able to show official results, so the financial statements, those alternative evidence are equally enforced. They are enforceable.
Thanks, Richard. I think it's good to know that there are alternative ways to prove, as you said. One option is previous month's accounts, as well as you said, a declaration. All right, let's move to our next scenario, which touches on a mix of commercial properties.
Yeah, Serene, just before that, I think I'll just add on, to the last point that Richard said just now. Apart from the accounts, also in terms of the earlier query that you had asked us about the whether lease agreement, does it have to be written, or how can you prove it? I think that question was framed more broadly, but in case the audience member was asking, in particular in the COVID Act context, they have actually said that for additional rental relief, you do need a written lease agreement, or at least some kind of written agreement to be shown, so that you can claim relief under the Act. So it really depends on the context the audience member is asking, and therefore generally, of course, contracts verbally it could be enforced to a certain extent, but for COVID relief in particular, we would need a written agreement as well.
Thanks, Renita. Yeah, I think that's the good clarification, and I think that's also a good reminder to the audience as well that, during this time, please get your housekeeping in order in terms of making sure your tenancy, your licenses agreement are written and you paid stamp duty. On top of that, please keep your accounts, because as you can see through the process, as I think Richard and Renita earlier shared, your landlord or the tenant will be asking you for proof that your business has dropped. So keeping accounts does go a long way in terms of helping to prove that. Let's move on to our next scenario on different commercial properties. The landlord owns various properties. The landlord leases a residential property to a home baker who uses the premises for her business and as her home. The landlord operates a co-working space and sells memberships. Member A pays a monthly fee to use any desk in the common area. The landlord leases a unit to tenant A, who sublets part of the unit to subtenant B. Tenant A's business is doing well, but subtenant B's business is doing badly. Is the landlord required to grant rental relief under the Covid-19 Act? There has been an uptick of home bakers and people carrying out businesses in their own homes. Renita, what are your thoughts about the home baker?
Yeah, I do think, thanks, Serene, and I do think that, the home baker situation is definitely an encouraging one. You have a lot of, enterprising housewives and otherwise as well, who are doing very well at home. You're tasting a lot of good creations from all around us. But unfortunately, I think in terms of the COVID Act, it's quite specific. It applies to the industrial and commercial properties. It does not extend to the residential properties. So in that sense, there is no rental relief that is being given to these smaller businesses that are being operated from home, and hopefully I think during this period they're actually doing quite well. So no direct rental relief. However, I would mention that, you know, beyond rental relief, that, you know, these home bakers of course should just be reminded there are during this period there was a home-based small-scale business scheme that has been introduced by HDB and URA, so that previously, while certain licenses or approvals were needed to operate at home, you know, I think this scheme actually does encourage many more businesses to operate from their homes and to sell even from their homes, you know, without having to comply with certain additional guidelines. So that's just an extra point as well.
Thanks, Renita. So I gather that the COVID-19 Act unfortunately does not apply to, I suppose, home businesses because they're working out of a residential property. But nonetheless, you know, do keep an eye out. As Renita said, there may be other government schemes or subsidies out there that perhaps you could apply or rely on. So next, we're looking at the co-working space, which I think is become a little bit more popular, you know, in terms of office use. Richard, for the co-working space, what are your thoughts?
Right. This particular scenario is similar to I think the very first scenario that we talk about, whereby I think scenario A, whereby a tenant actually or a supplier actually consign a shelf from say a supermarket to sell a product. So it's a similar situation, and this is of course it's not the goods that will be laid on the shelf. It's we people that be using the space. So again, if we look at the COVID Act, we are talking about a licensed immovable property. So these co-working space, if they're just renting a desk or even some sort of a room on a temporary basis and all that cannot be regarded as a lease, and therefore the benefit of the COVID-19 Temporary Measure Act does not extend to that protection. So in short, the scenario B situation, the Act does not protect these users, if you like, all right, those users that uses these services and all that, so they are not protected. However, in some of these co-working space, there are also tenants that actually permanently lease certain part of the premises. Now that's a different story altogether. If they permanently say lease a space and that's dedicated to them, again the license, they could use the license instrument, or they could use a leasing agreement. Either way, it works fine. It's still the spirit of the law is that is covered under the Temporary Measure Act, and therefore whatever that is relief that's available under the Act will be accorded to these tenants. Yeah, Serene.
Thanks, Richard. I think an interesting thought just came to my mind is that, I think this scenario, perhaps the co-working space, the way they had framed it in the agreement is a membership agreement. So I think, as you said, for basically you can use any desk, no specific desk, unlikely that you'll be able to rely on the Act. But in the case, as you said, there's a dedicated office or desk, there's a stronger argument to be made that, that the COVID-19 Act can be relied upon. So I think that brings up the question, does it matter if the agreement is labeled as a membership agreement rather than a license or lease agreement?
You see, we all know that law is about substance and not about form, right? You can name whatever you want, but the substance point that no stamp duty paid, there's no other the usual tenancies, the leasing terms in the contract, whatever you name it, that cannot be said that it is a lease or a leasing agreement or a license agreement, and therefore no. The short answer to that question, nope. The law is clear. It is about the substance, about the form. You can name whatever title the agreement is, as long as these ingredients are not covered, that the property concerns are not as defined as the dedicated immovable property for the purpose of leasing, then it doesn't cover under the Act.
Thanks, Richard. We've received a question from the audience. Would a rented place of worship qualify as a commercial premise for rental relief under the COVID-19 Act?
Well, I think this question I must pass on Rena because I'm a commercial lawyer. I don't do charity work enough. But maybe Rena, would you like to take this question and let me collect my thoughts on this?
Yeah, just I don't deal with this directly as well. But I do think that they have, there are certain stipulated places of property places that are set out, in the Act, whether industrial or commercial, and generally it comes down to the zoning. So often I would think that religious institutions would fall under commercial type of areas, and therefore be entitled to the relief, in that regard. Often they may also have, government landlords, and so it would clearly be, notified to them and passed down. So that's the more likely scenario. Again, it's always good to just check back with exactly what the property may be zoned under with the relevant landlord.
If I could recall, 2 Sundays ago, it was a major event for the 9th Heavenly God, whatever, where it's a 1-week celebration. Major. They will put the boat into the sea and all that. 2 Sundays ago, I attended, and I recalled the committee members were discussing. I was just a guest there, and I couldn't help to sort of join in the conversation. Yes, they were actually writing to the minister to ask for sort of relief and all that. So I support Renita's observation on this matter, that for place of worship, if the property type qualifies and the landlord actually received property rebate, then these benefits have to be passed on to the tenant. So God needs to have relief as well.
Thanks, Richard. Thanks. So I guess it's a useful, basically a useful tip, I suppose, in that, try and look at, even though you're using a place for religious worship, I guess big question mark, whether it's zoned as a place of worship or commercial, or are you, out of someone's home? So I think that's something that you need to consider. So let's look at the last situation on the subtenant, where basically tenant A is doing well, but subtenant B is doing badly. Renita, what's your advice or thoughts on this?
Yeah, I think this is interesting. Many a time, especially from the landlord perspective, or from any of the parties' perspective, we don't often know the entire situation being faced by the other side, let alone, a separate level further beyond. So in this case, I mean, subtenant B, if they are doing badly, if they meet all the other conditions that we've been talking about in this seminar, for additional rental relief, within the type of business, the type of property, and they're doing badly, less than 35% or more drop in earnings, then they should be entitled to that additional rental relief, and they should inform tenant A to then notify upwards to the landlord. And of course, if tenant A refuses to do so, for example, there are always ways for subtenant B also to directly notify the landlord. Usually most contracts don't prohibit direct communication, to go straight above. But in the worst case scenario, of course, there are also ways to, make use of the assessor adjudication mechanism to ask, the subtenant above, who is that landlord, to actually, make sure that the rebate is passed down to them, and to not prevent, to not refuse to do so. So there are various ways or mechanisms, either through relationship channels, communication channels, or through the legal mechanisms to deal with this.
Yes.
Thanks, Renita. I think that's just very practical, in that, as you said, basically try and reach out to the landlord. How would the landlord know that there's a subtenant, or what's the state of the subtenant's business?
Yes.
Thank you, Renita and Richard, for walking us through the different scenarios. Before we start the Q&A session, I would like to gently remind the audience that you can still submit your questions through the questions panel on your screen. Let's take our first question. This tenant had to move out of the premises during COVID, and I think Richard had mentioned about the moratorium. So the tenant was told to reinstate the space. and obviously he can't afford to do so. So must the tenant reinstate the space? And does a moratorium apply, for basically reinstating spaces? Richard, any thoughts?
Right. This happens during the 2 months of circuit breaker, whereby all, unless it's essential services, and I think at that point in time, all these reinstate work, renovation work is also not part of the essential services. Of course, even there are people who are providing such services. The feedback generally we got from our clients is that they couldn't get anybody to do that, right? So yes, it's a very real problem where the lease expired and they vacated the premises, they handed it over, but they could not reinstate. The point is that the Act clearly state very clearly that apart from all those rental relief and that is all stipulated, beyond that, the usual contractual terms of a lease still come into play. And that's the point that Renita made it very clear at the start of the seminar. So yes, the tenant is legally obligated to reinstate. Whether it can be reinstated in a timely fashion is a question. But in the event that the parties cannot, the tenant cannot do so, then of course the landlord have every right to dip into the security deposit to offset whatever what is to be done for reinstatement. So the short answer to your question, yes, the tenant is legally obligated to reinstate the property upon their departure.
Thanks, Richard.
Yes.
Renita, do you have anything to add to that?
I mean, not that much further. I think exactly what Richard is saying. I think those obligations remain. Definitely if there needs to be some further commercial understanding, for some reason, maybe, sometimes also I think in this period, a lot of contractor works have been stalled due to a lack of workers. So certain reinstatement works could not take place simply because the workers were not available. I think in all these situations, there are provisions and there are discussions that can take place to get the landlord's understanding, that the handover of the property may not take place as fast as one might imagine. In fact, I've seen quite a number of situations where one tenant even explains to the next tenant that might be coming in, that there might be a slight delay, and the next tenant also has to renovate and is in a difficulty with the workers, getting enough workers. So they completely understand. So I think as much as it's been a situation where it's challenging on many parties' sides, there has been quite a fair bit of commercial discussion that has also been going on and can take place in the context. Yeah.
Thanks, Renita. The next question is dealing with a landlord who is based overseas. So if a landlord is based overseas, does the COVID-19 Act apply? And how does the tenant bring the landlord before the COVID-19 assessor? Perhaps, Richard, if you could share your thoughts on this.
Certainly. No, the fact that the physical presence of the parties, whether it's a tenant or the landlord, it could be the tenant as well. Tenants could have the business run by its employees and all that. The physical well-being of the parties does not hamper the operation of the Act. Whatever relief that ought to be accorded to the relevant parties is still going to be executed. In the event that the assessment has to be taken before an assessor, there's no physical meetings required like what we are now. We are all in different locations. The assessor can still carry out the assessment. Parties will be communicated via email. They are supposed to file their paperwork through the MinLaw portal. If the assessors require additional documentary evidence that can be sent through via email or whatever expedient and legally accepted way by the assessor. So it doesn't hamper the work of the assessor, neither are the rights of the or obligations of the relevant parties be hampered the fact that any one of the parties are not physically in Singapore.
Thanks, Richard. The next situation, a tenant has a 1-year lease. Of course, due to the COVID-19 and financial difficulties, he wants to prematurely terminate his lease. However, the landlord refuses to refund his deposit. Is the landlord allowed to do that? Renita, any thoughts?
Yeah, so I think based on the current moment, if the tenant does have this lease, it is difficult for that the COVID Act at present doesn't give any right for the tenant to prematurely terminate the lease. It mainly gives additional rental relief, and it also, so for an immediate period, certain amount of 2 to 4 months rental relief, and then beyond that, also a deferred payment period so that you can only pay in the later part of the year, and even if you can't at that point, there's also provisions to pay by installment plan. So a lot of these measures have been put in place to help the tenant tide through this period. But in terms of a direct right to prematurely terminate the lease, that's not possible at this juncture, and because also the landlord will also be facing their own difficulties and financial hardships at this point of time. The other thing is also the landlord is entitled to take on the deposit, assuming the tenant just closes down, disappears, and leaves. But then demands for their deposit back. Contractually and at law, I think we do know that the landlord will also then face losses. It is a difficult period to get new tenants as well. And so, while they do have to act reasonably, they have to mitigate their losses, generally they would still be entitled to forfeit that deposit. And this is usually provided for in most of the contracts. So that's the current position, at least.
Yeah,
Thanks,
Serene, if I may add.
Sure, go on, Richard.
Yeah. Just to add on to what Rina has said, we will strongly advise the tenants not to abscond. Really don't lose sight on this particular issue. If really negotiate a proper exit with the landlord, because some of the leasing agreements provide very clear provision where the landlord has every right, not just forfeit the security deposit, which Renita has just mentioned earlier, they also can collect the unconsumed portion of the lease, and more importantly, a lot of the commercial leases with bigger landlords, such as Renita's organization, they actually made the tenant, the representatives, as personal guarantors. So they can go after the personal wealth of these tenants' representatives. So it's a very serious business. So really have to properly negotiate an exit. Yeah. Sorry.
Thanks, Richard. I think that's a very good point. In that don't just, as you said, abscond or try to ignore the situation, because the landlord will come back. And what would that happen? It's better to amicably try and resolve it. Because as everyone has pointed out, everybody is in this situation together. They acknowledge and recognize that it's a tough time for everyone. But not communicating your landlord or just disappearing would not facilitate or help resolve the situation. In fact, if the landlord is desperate enough, he can't contact you, very possibly he might take legal action, which is something which you would want to avoid. Your next question, this is for Richard.
Yes.
There is a arbitration clause in my tenancy agreement. Does that mean I can still apply for an assessor's determination under the Covid-19 Act?
Okay, the regulations is quite clear on this. Once there's any arbitration proceeding started, assuming that most of the agreements would have the arbitration clauses and all that, if they did not activate that, parties resort to private discussion. If they cannot mediate, and then they proceed to the notification without resorting to the help of arbitration process or legal proceedings, then yes, the notification for relief framework will kick in, and that will prevail. But once legal proceedings commence, or that arbitration is before the arbitrator or in the process of being arbitrated, then the notification of relief framework will not apply, unfortunately.
Thanks, Richard. Another similar question to this is that if there's an arbitration clause in the tenancy agreement, and I don't think this is dealing with a COVID-19 Act situation, but it's perhaps another kind of dispute, can I apply for my dispute to be resolved by the Small Claims Tribunal instead?
Well, I'll do the question first. Yeah, of course.
Sure.
Be feel free to chip in later. The contract is just a way to govern our relationship. If parties so decide, putting aside whatever that is stated in the agreement, and let's sort out our differences or our disputes in a more amicable way, or a more cost efficient way, that's fine through mediation. Or in this instance, maybe taking this matter to the small claim tribunal. That's fine. If I'm mistaken, as long as the lease is less than 2 years, that's covered under the Small Claim Tribunal Act. I think leases beyond that will not be considered. So that's something that the relevant applicants need to look at the Small Claim Tribunal Act to see whether the particular contract is covered under that act or not. If not, then the Small Claim Tribunal does not have jurisdiction to even resolve this matter. Yes, the short answer to that question, if there even there's arbitration clauses and all that in the contract, if at the first instance the tenant wants to take it to the SCT, Small Claim Tribunal, that's fine too. Yeah.
Thanks, Richard. Renita, do you have anything to add?
Yeah, I could just add on as well. So exactly as Richard has pointed out, it is important to check the jurisdiction of the or rather, whether this particular contract falls within the scope of the Small Claims Tribunal. So typically they hear claims that are up to 20,000, or if both parties agree, up to 30,000. And I think if it's residential, yes, maybe up to 2 years. But if it's industrial or commercial, they do hear all leases and licenses there as well, but you have to fall within that 20 or 30,000 cap. So exactly like Richard was pointing out, you would see whether you want to go through that mode of agreement with the other side to discuss. The other ways are also, of course, there's mediation and so on. But at the end of the day, the assessor mechanism is there. It's relatively straightforward. The timelines are very clear. So many parties would go there, and usually other proceedings would wait for the assessor adjudication to be complete, so that they would take that finding. Yeah, so that would usually be the mode of practice at the moment. Yeah.
Thanks, Renita. Our next question is, if a landlord sells his property, is he still liable for rental relief under the Covid-19 Act to the tenant, or does this all now fall on the new owner?
Well, this is getting very complex. Yes. Is this question directed at me?
Sure. Richard, why not share your thoughts?
All right, okay.
You volunteered, yes.
Did I? Okay. Well, Renita will be my very good backup. Yes, I think this questions or this scenario require a bit more elaboration. One, I think when we start a proceeding, we must then find the right party, right? We have the proper plaintiff rule. Who is the plaintiff and who is the right party to sue? If it can be very costly if we sue the wrong party. In this instance, let's say I'm the tenant and my landlord have changed, the proprietor have changed. Obviously, I may not be privy to the agreement between the buyer and seller of the property. So obviously, whoever is my current proprietor, obviously I will go at the first instant for the rental relief. So that is the first instant from my point of view. But if the existing proprietor feels that whatever agreements that he has agreed upon or she has agreed upon with the previous owner, that there's some sort of a coverage of the relief, then the current proprietor may actually bring in the former owner as a third party to indemnify whatever losses or damages that he may suffer from the lawsuit originated by the tenant. So to answer your question, it is quite facts-centric in this instance. By and large, the current parties will be the parties in litigation as far as dispute is concerned. If let's say there's other arrangement and all that, then it is for parties to bring in the relevant parties to address their claim. In a nutshell. Yeah, sure.
Thanks, Richard. Renita, do you have anything to add?
Yeah, I completely agree with what Richard has shared. So I think at the end of the day, this is a very logistical type of situation. So definitely the tenant might go to their then current landlord. But at the end of the day, usually the timelines are actually quite clear. For most landlords in a typical agreement, when a landlord sells the property, they would be liable up to a certain date. As the old landlord will be liable up to the date that they sell the property, and then once they've sold the property, usually there are notices that go out to the tenants to say, with effect from this date, this is your new landlord. And that usually is also the date that the new landlord takes on all the future obligations. So in terms of the authorities as well, that is how they would also deal with the landlords, on that basis. Prior to a certain sale date, they would deal with the old landlord, and then subsequent to that, they will deal with the new landlord. So both for tax purposes as well as for relief purposes, passing down of rebates, they would do this way. From a tenant perspective, as Richard has pointed out, I mean, you would likely go to your then current landlord and hopefully seek their assistance also, and maybe reaching out to the old landlord, or try to issue certain notices on your own. But usually you would want to go through your current landlord first, and only if they don't help you, then you might have to help yourself and then write back to the old landlord, or see what other what other way you can claim for this as well.
Thanks, Renita. I think for landlords who are thinking of selling, or landlords who are thinking of buying, good to sort out this issue, especially if you're trying to buy or you bought property during this period, to make sure all of this has been covered off. If not, as you can hear from Richard and Renita, most likely the tenant would turn to you because you're the most accessible at this point in time. We have one last question, and perhaps this is a more practical question. So there's a tenant, and he's only interacted with his property agent for all matters. He doesn't know the landlord's email address or registered address. So how does he go about serving the notification of relief? Perhaps, Richard, if you could share your thoughts on this.
Okay. Well, then, if he has at all material times that the agent has made himself or hold herself out as the representative of the landlord, then of course he is obligated to receive notice, and then it is also his or her obligation to pass on that notice to the landlord. It may well be that he or herself may be the landlord, although that's against the housing agents regulations, but that's beside the point, assuming that it's a genuine situation whereby the landlord doesn't want to be seen. Yes, the notification will be served on the agent, and is good service. So in that instant, the landlord cannot then come and turn around and say, sorry, this service is defective. So the service will be good. As if it was served on the agent, it's as good as serving on the landlord.
Thanks, Richard. Renita, do you have anything to add?
Yeah, just off the top of my mind, very practically thinking about it as well. I'm surprised that the tenant may, I mean, but it is possible, that the tenant has largely been dealing with the agent. I would have thought that most agreements or contracts that they would have entered into, they would know who the landlord is. And in this day and age, maybe, it's still possible to Google to try to find out the registered address of the landlord. So that you could at least serve it at the registered address, directly to the landlord, and that is one way of notification to them. Or even better if they have a website and you can find all the contact details there. But it's also, I think, really good to know, as Richard said, that we could also serve it on the agent in certain cases where they have made themselves out to be the representative of the landlord, to receive service as well. I mean, just also because we mentioned that this is the last question possibly for this section, I would also just mention that, overall, I think everything that Richard and I have shared about the measures and the help that can be given from both tenant and for both tenant and landlord perspective, a lot of this is set out very helpfully on the Ministry of Law website. I think they have done an excellent job in setting out the circulars and the explanation very clearly, even for the public to use and to know exactly what is the mechanism when they want to make a complaint and within how many days they have to give notice to the other side, etc. So I think that will be a very helpful starting point for most of anyone who is watching as well.
Thanks, Renita. And that concludes our Q&A session. We hope that you found our webinar useful. A survey will be sent to you, and we appreciate your feedback, which will be used to improve our future webinars. Please remember to download the materials for the webinar before logging off. They can be found at the Files tab on your screen. Thank you again, Richard and Renita, for your time and your expertise. On behalf of Law Society Pro Bono Services, thank you for joining us today and have a good week ahead.
Thank you.
Thank you.